The morning sun peeked through the faded curtains as June Wong sat at her kitchen table, staring at the letter that had arrived the day before. Her weathered hands trembled slightly as she read it for what must have been the 20th time. The words hadn't changed. Bellworth Development was taking her to court to force the sale of her home. "This can't be happening," she whispered to herself, glancing around the modest kitchen where 3 generations of her family had prepared meals, celebrated birthdays, and shared their daily lives. At 58, June had spent her entire life in this house. After her parents passed, the family home had become not just a shelter but a living museum of memories. June worked as a cashier at Friendly Market, the local grocery store where she'd been employed for the past 12 years. It wasn't glamorous work, but it paid the bills and allowed her to keep the house that her grandfather had built with his own hands. The property taxes had gone up as the neighborhood transformed around her, with new luxury condos and upscale shops replacing the familiar small businesses and modest homes she'd known all her life. The phone rang, startling her out of her thoughts. "Hello? June, it's May. Have you made a decision about that letter?" Her friend's voice was laced with concern. "I can't afford a lawyer, May. The quote I got yesterday was more than I make in 3 months. But you can't just give up. That house is everything to you." June's eyes drifted to the old oak bookcase in the corner of her living room. Behind the framed family photos and knickknacks sat a row of legal textbooks, their spines cracked from years of use. "I'm going to represent myself," she said, the words coming out before she'd fully formed the thought. "What? But you're not a lawyer."
"No, but I worked as a legal secretary for 15 years before I had to quit to take care of Mom. I've been reading about property law for years."
"It's always interested me. Reading books isn't the same as practicing law, June." "I know, but what choice do I have? Bellworth has already pushed out half the neighborhood with their tactics. If I don't fight, I lose everything." After hanging up, June walked to the bookcase and pulled out a well-worn volume on property law. For years, she'd spent her evenings reading these books, fascinated by the way the legal system worked. It had started when she was a young woman working at Harrison and Finch law offices. The attorneys there had noticed her interest and sometimes explained cases to her during lunch breaks. After leaving to care for her ailing mother, she'd continued her informal education, reading whatever she could find on the subject. 2 weeks later, June found herself walking up the courthouse steps, her heart pounding in her chest. She wore her best outfit, a simple blue dress she usually saved for special occasions, and carried a worn leather bag containing her carefully organized notes and documents. As she pushed through the heavy doors, the cool air inside the courthouse washed over her. The marble floors and high ceilings made her feel small and out of place. She checked the listing and made her way to courtroom 3, where her case would be heard. Inside, she immediately spotted the Bellworth team, 3 attorneys in expensive suits, huddled around a table covered with sleek laptops and perfectly organized files. The lead attorney, a tall man with silver hair and glasses, glanced up as she entered. His eyes quickly assessed her modest appearance before dismissing her with a slight smirk. June took a deep breath and walked to the other table. As she set down her bag, she could hear whispers from the Bellworth table. "That's her. Where's her attorney? Apparently she's representing herself." A barely suppressed chuckle followed. June pretended not to hear as she arranged her papers. Her hands were steady now, despite the butterflies in her stomach. She had spent every waking moment of the past 2 weeks preparing for this day, reviewing her grandfather's property documents, studying relevant cases, and practicing what she would say. The bailiff called the court to order as Judge Rivera entered. The judge, a stern-looking woman in her 60s, took her place and reviewed the docket. "Bellworth Development versus Wong, case number 47293. Are both parties present?" "Yes, Your Honor," the silver-haired attorney said, standing smoothly. "Richard Hargrove, representing Bellworth Development." "June Wong, representing myself, Your Honor," June said, working hard to keep her voice from trembling. Judge Rivera looked at June over her reading glasses. "Ms. Wong, you understand that you're entitled to legal representation? The court can provide resources if you cannot afford an attorney." "Yes, Your Honor. I've chosen to represent myself." The judge nodded, though her expression suggested she thought this was unwise. "Very well. Mr. Hargrove, you may present your opening statement." Hargrove stood and buttoned his jacket in a practiced motion. His voice filled the courtroom with confident authority. "Your Honor, this is a straightforward case. Bellworth Development has purchased 17 properties in the Oak Hill neighborhood, for a revitalization project that will benefit the entire community. Ms. Wong's property is the last remaining holdout, preventing progress that would create jobs and improve the local economy. We have offered fair market value, indeed more than fair, but Ms. Wong has refused all reasonable offers. We're simply asking the court to enforce the Urban Development Act of 2018, which allows for compulsory purchase in cases of community improvement. June listened carefully, noting how he made it sound like she was standing in the way of progress rather than fighting for her home. When Hargrove finished, the judge turned to her. "Ms. Wong, your opening statement?" June stood, feeling all eyes in the courtroom on her. She noticed a few spectators in the back row, neighbors who had already sold to Belworth, curious to see what would happen. "Your Honor," she began, her voice quieter than Hargrove's but clear. "My grandfather built our family home in 1945 after returning from the war. My family has lived there for 3 generations. The house isn't just property to me, it's my heritage and my home." She paused, gathering her thoughts. Belworth claims they've offered fair market value, but their offers don't account for the historical value of the property or the fact that housing prices in the area have been artificially depressed by their own aggressive tactics. One of the junior attorneys at the Belworth table leaned over to whisper something to Hargrove, who smiled slightly. Furthermore, June continued, the Urban Development Act they cite requires proving that the development serves essential community needs, not just commercial interests. Their plans show luxury condos and high-end retail, not affordable housing or necessary services for existing residents. Hargrove's smile faded slightly as she spoke. She could see he hadn't expected her to know the details of the law. "I intend to show that Belworth has not met the legal requirements for compulsory purchase and has engaged in questionable practices to acquire properties in our neighborhood." As she sat down, she heard more whispers from the Belworth table. The junior attorneys were looking at her with reassessed interest, though still with obvious skepticism. Judge Rivera nodded. "Thank you, Ms. Wong. Mr. Hargrove, please call your first witness." Hargrove called Thomas Reynolds, Belworth's chief planning officer. The well-dressed executive described the development plans with rehearsed enthusiasm, showing glossy renderings of modern buildings with green spaces and pedestrian-friendly walkways. "This project will transform a declining neighborhood into a vibrant community center," Reynolds concluded, smiling confidently at the judge. "Ms. Wong, your cross-examination," Judge Rivera said. June stood, feeling surprisingly calm now that the moment had arrived. She had prepared questions for each likely witness. "Mr. Reynolds, these renderings look lovely," she said, approaching the witness stand. "Could you point out where on these plans there's any affordable housing?" Reynolds hesitated. "Well, the market determines. It's a yes or no question, Mr. Reynolds. Is there any designated affordable housing in these plans?" "No, not specifically," he admitted. "And could you show us where the community services are? A library, perhaps, or a community center?" Reynolds shifted uncomfortably. The retail spaces could potentially house such services. "But there's no specific plan for them, correct?" "Correct." June could feel the energy in the courtroom shift slightly. The spectators were leaning forward, and even Judge Rivera seemed more attentive. "One last question. Mr. Reynolds, in your initial community impact statement, you claimed this development would serve the needs of the existing community. Given that the average income in Oak Hill is $42,000 per year, and your own marketing materials state that condos will start at $500,000, how exactly will this development serve the existing community?" Reynolds looked to Hargrove for help, but the attorney could only watch as his witness stumbled. "We believe the economic benefits will trickle down to all residents," Reynolds finally said. "Thank you, Mr. Reynolds. No further questions." As June returned to her seat, she caught a glimpse of Hargrove's face. The smirk was gone, replaced by a calculating look. She knew she had surprised them, but this was only the beginning. The real battle was still to come, and they were not going to underestimate her again. For the first time since receiving the letter, June felt a flicker of hope. She might be a simple grocery store clerk to them, but she was about to show them there was nothing simple about fighting for one's home. The next morning, June arrived at the courthouse earlier than necessary. She wanted to gather her thoughts before facing the Belworth team again. Yesterday's small victory had given her confidence, but she knew the real battle was just beginning. As she settled at her table and arranged her documents, she noticed the courtroom filling up. Word had spread about the grocery clerk standing up to the development giant. Several of her neighbors were there, along with curious locals and even a reporter from the community newspaper. The Belworth legal team entered as a unit, their expressions noticeably different from yesterday. Gone were the dismissive smirks, replaced by focused determination. Richard Hargrove nodded curtly in her direction, before huddling with his colleagues in intense discussion. "All rise," called the bailiff as Judge Rivera entered. After everyone was seated, the judge reviewed her notes. "We'll continue with Belworth Development versus Wong. Mr. Hargrove, you may call your next witness." Hargrove stood smoothly. "Your Honor, we call Dr. Philip Chen, our economic impact analyst." A thin man with wire-rimmed glasses took the stand. After being sworn in, he launched into a detailed presentation about the economic benefits of the Belworth project, complete with charts and projections. "Our models show an estimated 17.3% increase in local property values, creation of approximately 340 jobs, and a 22% increase in tax revenue for the municipality," he concluded, adjusting his glasses with a satisfied expression. Judge Rivera turned to June. "Your cross-examination, Ms. Wong?" June approached the witness stand with her notebook. "Dr. Chen, these numbers sound impressive. Could you explain how you calculated the job creation figure?" "Certainly," he replied with confidence. "We used standard economic projection models based on similar developments in comparable markets." "Which specific developments did you use as your comparison points?" The economist hesitated. "The riverfront project in Westlake, the Heights in Pinecrest, and Oakwood Commons." June nodded as if considering this. "I'm familiar with those developments. Aren't those all in neighborhoods with median incomes at least twice that of Oak Hill?" "Well, yes, but... And didn't all three of those projects receive significant public funding that your project doesn't have?" Dr. Chen looked uncomfortable. "There were some municipal bonds involved, yes. So you're comparing apples to oranges, wouldn't you say?" June pressed. "Using wealthy neighborhoods to predict outcomes in a working-class area?" Before he could answer, Hargrove stood. "Objection, Your Honor. Ms. Wong is not qualified to critique economic methodologies." "Your Honor," June countered, "I'm simply asking for clarification on the witness's methodology, which is within my rights as a cross-examiner." Judge Rivera nodded. "Overruled. The witness will answer." Dr. Chen cleared his throat. "Our models adjust for demographic differences." "Could you explain these adjustments to the court?" June asked. "Well, it's quite technical, involving multivariate regression analysis and elasticity coefficients that—" "In simple terms, please," June interrupted gently, "so the court can understand." The economist's professional demeanor cracked slightly. "Essentially, we apply multipliers to account for different market conditions." "And what multiplier did you use for Oak Hill specifically?" Dr. Chen glanced at Hargrove, who was watching with a tight expression. "A 0.7 factor," he admitted reluctantly, "meaning, your projection is that our neighborhood will achieve only 70% of the benefit that wealthier neighborhoods received." "That's a simplification, but technically correct." "Thank you," June said. "Now about those 340 jobs, how many are permanent positions versus temporary construction jobs?" By the time June finished her cross-examination, Dr. Chen's confident predictions had been revealed as optimistic guesswork based on questionable comparisons. As she returned to her seat, she noticed several jurors watching her with newfound respect. Hargrove, however, was not about to let her small victories continue. He called his next witness immediately. "Your Honor, we call Lisa Jackson, City Planning Commissioner." A professionally dressed woman took the stand, projecting authority and competence. After establishing her credentials, Hargrove led her through testimony about the city's development priorities and how the Belworth project aligned with them. "The Oak Hill area has been designated for revitalization since 2019, Commissioner Jackson stated. The Belworth proposal satisfies all our criteria for urban renewal." When it was June's turn to cross-examine, she approached confidently. "Commissioner Jackson, could you tell the court what specific criteria must be met for invoking eminent domain under the Urban Development Act?" "Of course," the commissioner replied smoothly. "The development must serve essential community needs, provide significant economic benefit, and there must be no reasonable alternatives." "Thank you." Does the law specify what constitutes essential community needs? It includes affordable housing, public facilities, infrastructure improvements, and which of those are included in the Bellworth Plan? June asked. Well, the economic benefits. I'm asking specifically about the essential community needs you just listed, June persisted. The commissioner paused. The plan doesn't directly include those elements, but the general improvement to the area. So it doesn't actually meet the first criterion you mentioned? Hargrove stood abruptly. Objection, Your Honor. Ms. Wong is badgering the witness and mischaracterizing the law. I'm simply asking for clarification of the commissioner's own statement, June responded. Overruled, said Judge Rivera. The witness will answer. Commissioner Jackson straightened her jacket. The law allows for broad interpretation of community needs, including economic revitalization. I see, June said. Now regarding alternatives, has the city explored any other options for the Oak Hill area besides selling to Bellworth? There have been discussions, the commissioner admitted. Could you elaborate on those discussions for the court? As the commissioner reluctantly detailed the other proposals that had been summarily dismissed, including a community land trust that would have preserved affordable housing, June carefully noted the jurors' reactions. By lunchtime, the mood in the courtroom had shifted. While June had scored points, Hargrove was growing visibly frustrated with her questioning. As Judge Rivera called the lunch recess, June overheard him speaking harshly to his junior associates. How did you miss these vulnerabilities in our preparation? She's a grocery clerk, for heaven's sake. June quietly gathered her things and headed to the courthouse cafeteria. She sat alone with a simple sandwich and tea, reviewing her notes for the afternoon session. She was so absorbed that she didn't notice someone approaching until they spoke. Mind if I join you? Looking up, she was surprised to see one of the jurors, an older woman with kind eyes. June hesitated, knowing there were rules about juror contact. I don't think we're supposed to speak during the trial, she said carefully. The woman smiled. You're right. I just wanted to say that my mother fought to keep her home 2 years ago. Different circumstances, but I recognize the courage it takes. She nodded respectfully and moved on before June could respond. The brief encounter fortified June's resolve. As she returned to the courtroom, she noticed Hargrove and his team had rearranged their seating, with a young female attorney now positioned closer to the center. When proceedings resumed, Hargrove called his final witness of the day. We call Terrence Powell, Bellworth Development's chief legal officer. A distinguished-looking man with a commanding presence took the stand. After establishing his credentials, Harvard Law School, 20 years of experience, numerous accolades, Powell began, explaining the legal basis for Bellworth's case with an abundance of technical language. The statutory framework clearly establishes our right to proceed under Section 4.7b of the Urban Development Act, which provides for transfer of title under the doctrine of essential utility, Powell stated, his voice carrying an impressive authority. June noticed several jurors looking confused by the jargon. When her turn came, she approached the stand with her worn legal dictionary visibly in hand, placing it on the podium with deliberate care. Mr. Powell, you've used quite a bit of legal terminology in your testimony, she began. I'm just a grocery clerk, as everyone here knows, so I hope you'll bear with me as I try to understand. She opened her dictionary with exaggerated slowness. Could you explain what you mean by essential utility in simple terms for those of us without Harvard law degrees? Several spectators chuckled, and Powell's expression tightened. It refers to the necessary public benefit derived from the development, he said curtly. Thank you, June said with exaggerated gratitude. Now you mentioned Section 4.7b. Could you read that section for the court? I don't have the exact text in front of me, Powell said stiffly. That's all right. I have it right here. June produced a copy of the Urban Development Act. Section 4.7b states, and I quote, transfer of property may be mandated only when the proposed development directly addresses critical community needs, including but not limited to affordable housing, public health facilities, or infrastructure necessary for public safety. Would you agree that's what it says? Powell glanced at Hargrove, who was writing furiously on a legal pad. That is the text, yes. But the interpretation— Your Honor, Hargrove interrupted. Standing legal interpretation is a matter for the court, not for witnesses or amateur litigants. He nearly spat the last words. The judge frowned. Mr. Hargrove, while you're correct that interpretation is ultimately the court's province, Ms. Wong is entitled to question the witness on the factual basis of his assertions. Please continue, Ms. Wong. Thank you, Your Honor, June said. She turned back to Powell. Mr. Powell, can you identify where in the Bellworth proposal it addresses any of the critical community needs mentioned in the section you cited? As Powell struggled to formulate an answer that wouldn't undermine his company's case, a ripple of whispers spread through the spectators. June maintained her composed expression, but inside she felt a growing confidence. The Harvard-educated lawyer was now reaching for his water glass, buying time before responding. His discomfort was palpable, and June knew she had found the crack in Bellworth's legal armor. The community benefits are implied in the overall economic impact, he finally said, his authoritative tone notably diminished. June nodded thoughtfully. So not explicitly stated, but implied. I see. As she returned to her seat, she noticed several jurors nodding slightly, following her logic. The Bellworth team was huddled in urgent consultation, their earlier confidence visibly shaken. Judge Rivera checked the time. We'll adjourn for today and resume tomorrow morning at 9 a.m. As June packed up her materials, she felt someone watching her. Looking up, she met Hargrove's gaze. His expression was no longer dismissive or even angry. Instead, she saw something new in his eyes. Concern. June woke before her alarm the next morning, her mind already racing through the day ahead. Yesterday had gone better than she'd dared hope, but she knew Bellworth wouldn't go down without a fight. Today would be crucial. It was her turn to present her case. She brewed a pot of tea and sat at her kitchen table, surrounded by stacks of carefully organized papers. Her fingers traced the edge of an old leather-bound album she'd pulled from the attic last night. It contained yellowed newspaper clippings, legal documents, and photos that might prove to be her most powerful evidence. When June arrived at the courthouse, the atmosphere had changed noticeably. The hallway outside Courtroom 3 was crowded with spectators, including several of her neighbors and even a few local reporters. As she made her way through, people nodded respectfully or offered encouraging smiles. Inside, the Bellworth team had expanded. 2 additional lawyers sat behind Hargrove, and a woman June recognized as the company's PR director was taking notes in the back row. Clearly, Bellworth was taking her more seriously now. Judge Rivera called the court to order promptly at 9. Good morning. Before we continue, I want to remind everyone that this is a court of law, not a public forum. I've noticed increased attendance and want to ensure decorum is maintained. She turned to June. Ms. Wong, you may call your first witness. June stood, her heart pounding, but her voice steady. Your Honor, I'd like to call myself as a witness. The judge nodded. Very well. Please take the stand. After being sworn in, June settled into the witness chair facing the courtroom. From this new angle, she could see all the faces watching her. The skeptical Bellworth attorneys, the attentive jurors, her supportive neighbors. Ms. Wong, Judge Rivera prompted, since you're representing yourself, you may make your statement to the court. June took a deep breath. Thank you, Your Honor. I'd like to begin by explaining why my home at 427 Oak Street is more than just property to me. She described how her grandfather, Liang Wong, had come to America in 1937, working odd jobs and saving every penny. After serving in World War II, he was able to buy the land and build the house himself. The elm tree in the backyard was planted the day my father was born, she said, her voice warm with memory. The height marks of 3 generations are penciled on the kitchen doorframe. She then moved to address the legal aspects of her case. While Bellworth has argued that their development serves the public good, I will demonstrate that their plan fails to meet the statutory requirements for invoking eminent domain under the Urban Development Act. As she spoke, June's demeanor subtly shifted. Her posture straightened, her terminology became more precise, and her delivery grew more confident. Several of the jurors leaned forward, noticing the change. Furthermore, she continued, I will show that Bellworth Development has engaged in a pattern of predatory practices, deliberately targeting vulnerable homeowners and using questionable tactics to acquire properties below market value. Richard Hargrove shifted uncomfortably in his seat, exchanging glances with his colleagues. Judge Rivera looked at June with increased interest. Ms. Wong, you seem quite familiar with the legal aspects of this case. June nodded. Yes, Your Honor. Before working at Friendly Market, I spent 15 years as a legal secretary at Harrison and Finch, specializing in property law. While I don't have a law degree, I've continued studying legal texts and relevant cases in my spare time. A murmur ran through the courtroom. June could see the Bellworth attorneys frantically whispering to each other. This clearly wasn't in their research about her. I see, said the judge. Please continue. June proceeded to outline her defense with precision and clarity. She referenced specific sections of property law, cited relevant cases, and methodically dismantled Bellworth's arguments point by point. When she finished her testimony, Judge Rivera turned to Hargrove. Mr. Hargrove, your cross-examination? Hargrove approached the stand with careful neutrality, his earlier condescension notably absent. Ms. Wong, your personal attachment to your property is understandable, but sentiment doesn't override the needs of the broader community. Wouldn't you agree? The law doesn't pit sentiment against community needs, June replied calmly. It requires that developments claiming to serve the community actually do so in specific, defined ways that Bellworth's plan fails to address. But you would agree that urban renewal benefits everyone in the long term? When done properly, yes. When it displaces lifelong residents to build luxury condos most locals can't afford? No. Hargrove changed tactics. You mentioned working as a legal secretary years ago. That hardly qualifies you to interpret complex property law. June's expression remained composed. My role at Harrison and Finch involved drafting and reviewing property contracts, researching case law, and preparing legal briefs. The attorneys there recognized my aptitude and often included me in case discussions. While I don't claim to be an attorney, I understand the relevant legal principles. Hargrove looked skeptical. Yet you're a grocery clerk now. I left legal work to care for my mother when she became ill. After she passed, I needed a job with flexible hours to continue raising my younger brother. Life doesn't always follow a straight path, Mr. Hargrove. Several jurors nodded sympathetically. Hargrove tried another approach. Even with your background, you must realize that Bellworth's resources give them access to the top legal minds in the state. How can you possibly hope to prevail against their expertise? June smiled slightly. The law doesn't belong only to those who can afford expensive attorneys, Mr. Hargrove. Justice should be accessible to everyone. Frustrated by her composed responses, Hargrove returned to his seat. No further questions. Judge Rivera turned to June. You may step down, Ms. Wong. Would you like to call another witness? Yes, Your Honor. I'd like to call Mrs. Helen Patel. An elderly woman with silver hair made her way slowly to the witness stand. After being sworn in, she smiled warmly at June. Mrs. Patel, could you tell the court how long you've lived in Oak Hill? June asked. 63 years, dear. My husband and I bought our house in 1962. And could you describe your experience with Bellworth Development? Mrs. Patel's smile faded. They started coming around last year. First with letters, then phone calls, then people at my door, always saying I should sell before property values dropped. When I said no, they became insistent. Could you elaborate on insistent? They called at all hours, sent people to take pictures of my house, saying they were documenting code violations. One man said I'd be forced out eventually, so I might as well take their offer while it was still available. Did you eventually sell to them? Yes, Mrs. Patel sighed. After they sent a notice claiming my property had multiple violations that would cost thousands to fix. I'm on a fixed income. I couldn't fight them. And how did the amount you received compare to market value? It was about half what my neighbor got 2 years earlier for a smaller house. June presented several more witnesses with similar stories, building a compelling picture of Bellworth's tactics. As the last witness stepped down, Judge Rivera checked the time. We'll take a 15-minute recess, she announced. In the hallway, June sipped from a water fountain, trying to calm her nerves for what came next. She was about to present her most important evidence. Quite a performance in there, came a voice behind her. She turned to find Richard Hargrove watching her with grudging respect. It's not a performance, Mr. Hargrove, it's the truth. The truth is, development is inevitable, he said. Oak Hill is prime real estate. Bellworth may be the current developer, but if not them, someone else will come along. Why fight the inevitable? Because some things are worth fighting for, June replied simply. And because the law is supposed to protect people, not just profits. Hargrove studied her for a moment. We could still settle this amicably. Belworth could offer a premium, say 30% above market value. You could buy a nice place anywhere you want. June shook her head. It's not about the money. It's always about the money eventually, he said with a hint of weariness. Not this time, June replied, turning back toward the courtroom. When court resumed, June approached the bench. Your Honor, I'd like to present evidence regarding a legal precedent directly relevant to this case. She produced the leather album she'd brought from home and removed several documents. These are records from the case of Westside Community versus Palmer Development, 1979. The issues were remarkably similar to the present case, with a developer attempting to invoke eminent domain for a commercial project that lacked clear community benefit. June handed copies to the judge and to the Belworth team. In that case, the court ruled that aesthetic improvements and general economic benefits were insufficient, grounds for forced property transfer without specific provisions for community services or affordable housing. Hargrove frowned as he scanned the documents. Your Honor, this case isn't widely cited in property law. We need time to review these materials. It's not widely cited because Palmer Development buried it, June explained. They settled out of court after the initial ruling and had the record sealed as part of the agreement. But I have access to the original documents because my grandfather, Ling Wang, was one of the plaintiffs. Ripple of surprise went through the courtroom. The precedent, established in that preliminary ruling directly, contradicts Belworth's interpretation of the Urban Development Act, June continued. And while the case was settled, the legal reasoning in Judge Carlton's ruling remained sound and applicable. She turned to face the Belworth team directly. I believe Belworth's attorneys were unaware of this case because it was deliberately obscured. But its relevance to our current situation is undeniable. Hargrove's face had gone pale as he leafed through the documents. The junior attorneys beside him were frantically searching on their laptops, presumably trying to find any information on the case June had cited. Judge Rivera studied the documents carefully. This is indeed relevant material, Ms. Wong. Mr. Hargrove, the court will grant you until tomorrow morning to review these documents and prepare your response. As the judge adjourned for the day, June gathered her things, aware of the stunned expressions on the faces of the Belworth team. For the first time since this battle began, she allowed herself to believe she might actually win. June barely slept that night. She sat at her kitchen table until well past midnight, reviewing her notes and preparing for what would surely be Belworth's aggressive response to her grandfather's case. When she finally crawled into bed, her mind kept racing through possible scenarios and counter-arguments. Morning came too quickly. As she dressed in her best blue dress, the same one she'd worn on the first day, she noticed her hands were steadier than they'd been in days. Whatever happened today, she had fought with everything she had. The courthouse was buzzing with activity when she arrived. Word had spread about the grocery clerk who was holding her own against one of the biggest development companies in the state. A small crowd of supporters greeted her on the steps, including several neighbors who had already lost their homes to Belworth. You're speaking for all of us now, June, said Mrs. Patel, squeezing her hand. Inside, the courtroom was packed. June noticed two new faces at the Belworth table, older men in expensive suits who radiated authority. One was whispering intently to Hargrove, who nodded with a grave expression. At precisely 9 a.m., Judge Rivera entered and called the court to order. Before we proceed, I understand Belworth Development has filed an emergency motion this morning. Mr. Hargrove? Hargrove stood, his demeanor noticeably different, less arrogant, more businesslike. Yes, Your Honor. After reviewing the documents Ms. Wong presented yesterday, we've filed a motion to dismiss the Westside Community case as irrelevant precedent. On what grounds? Judge Rivera asked. The cases are fundamentally different, Your Honor. The Palmer Development case involved municipal land, whereas the current matter concerns private property. Additionally, the Palmer case was decided under the previous urban planning statute, which was replaced by the current Urban Development Act in 2018. June felt her stomach tighten. Hargrove had found an angle to attack. Furthermore, Hargrove continued, the Palmer case was settled out of court, meaning the judge's preliminary ruling never established binding precedent. We've brought in William Foster, our senior legal counsel, who has prepared a detailed brief on this matter. He gestured to one of the new men at their table. Judge Rivera turned to June. Ms. Wong, would you like to respond to this motion? June rose slowly, gathering her thoughts. Your Honor, while it's true that the Palmer case was ultimately settled, the legal reasoning in Judge Carlton's initial ruling remains sound. The principles at issue, what constitutes essential community needs and the limits of eminent domain for primarily commercial projects, are identical to our present case. She paused, then continued with growing confidence. As for the Urban Development Act replacing the previous statute, if we examine Section 1.2 of the current Act, it explicitly states that it builds upon established principles of the Urban Planning Statute. The foundational elements remained unchanged. June produced a document from her folder. I've highlighted the relevant passages showing the continuity between the two laws. May I approach the bench? Judge Rivera nodded, looking impressed. June handed copies to both the judge and Hargrove's team. Additionally, June continued, while the Palmer case did involve municipal land, the judge's ruling specifically addressed broader principles applicable to all eminent domain cases, stating, and I quote, "The mere promise of economic improvement, without specific provisions for community services, does not constitute the public necessity required for property transfer, regardless of whether said property is publicly or privately held." The courtroom was silent as Judge Rivera reviewed the documents, occasionally glancing up at June with a thoughtful expression. Finally, she set the papers down. I'm denying the motion to dismiss the precedent, she announced. While the Palmer case doesn't constitute binding precedent due to its settlement, the legal reasoning is relevant to our current proceedings and will be considered accordingly. She looked at Hargrove. You may proceed with your response to Ms. Wong's evidence. Hargrove nodded stiffly and called William Foster to the stand. The silver-haired attorney projected gravitas as he was sworn in, his voice resonant and authoritative. Mr. Foster, please state your credentials for the court, Hargrove requested. I've been practicing property law for 43 years. I served as chief counsel for the State Land Use Commission for 12 years and have argued before the Supreme Court on matters of eminent domain. I literally wrote sections of the current Urban Development Act. And what is your assessment of the Palmer case Ms. Wong has presented? Foster adjusted his glasses. While Judge Carlton's reasoning was sound for its time, development law has evolved. The modern understanding recognizes that economic revitalization itself constitutes a public good. The Palmer case represented an older, more restrictive view. When it was June's turn to cross-examine, she approached cautiously. Foster was formidable, and she knew it. Mr. Foster, you mentioned you helped write the Urban Development Act. Which sections, specifically? Primarily sections 2 through 7, dealing with commercial development zones. Did you work on section 4.7, which we've been discussing? No, that was added later in committee. June nodded. So you weren't involved in crafting the specific language requiring developments to address critical community needs? Not directly, no. Mr. Foster, are you familiar with the legislative history of that section? The attorney hesitated, clearly surprised by the question. In general terms, yes. June retrieved another document from her folder. This is the transcript from the Legislative Committee hearing where Section 4.7 was debated. Assemblyman Rodriguez specifically cited the Palmer case as inspiration for the language, stating that they wanted to preserve the wisdom of Judge Carlton's ruling while creating a more workable framework. As Foster reviewed the transcript, his confident expression faltered slightly. Isn't it true, Mr. Foster, that rather than representing an outdated view, the Palmer case actually informed the very section of law that Bellworth is trying to invoke today? Foster looked to Hargrove, who was frantically flipping through papers. I wasn't aware of this specific connection, Foster admitted reluctantly. June pressed her advantage. In fact, the committee strengthened the language, making it more specific about what constitutes community needs, didn't they? Yes, Foster conceded. They did. By the time June finished her cross-examination, Foster's testimony had been severely undermined. As he stepped down, the tension in the courtroom was palpable. Hargrove called two more witnesses, another legal expert and a city council member, but neither could effectively counter the connection June had established between her grandfather's case and the current law. When Bellworth finally rested their response, Judge Rivera turned to June. Ms. Wong, your closing statement. June moved to stand before the jury. She took a deep breath, looking at each of them in turn. When I first received Belworth's letter telling me they were taking me to court, I was terrified, she began simply. I'm not a wealthy woman. I work at a grocery store. My home isn't fancy, but it's mine, or at least I thought it was. She gestured toward the Belworth team. They thought I would be easy to intimidate. They've used the same tactics throughout our neighborhood. Pressure, harassment, and legal threats to force people to sell their homes for a fraction of what they're worth. They assumed I wouldn't fight back because I couldn't afford an expensive attorney. June's voice grew stronger. But what they didn't understand is that some things are worth fighting for. My grandfather built that house with his own hands after serving this country in war. My father was born there. My mother died there. Every corner holds memories that can't be replaced by any amount of money. She turned to face the full courtroom. This case isn't really about one house or one development. It's about whether the law protects only those who can afford to buy influence or whether it protects all of us. It's about whether words like community needs actually mean something, or whether they're just empty phrases corporations can twist to justify taking whatever they want. June held up the Urban Development Act. The law is clear. Eminent domain requires a genuine public benefit. Affordable housing, community services, infrastructure improvements. Belworth's plan offers none of these things. They want to replace our homes with luxury condos and high-end stores that none of us could afford to live in or shop at. She paused, looking at the jury with quiet dignity. I'm not against progress or development, but true progress lifts everyone up. It doesn't push people out of their homes to increase someone else's profits. June returned to her table and sat down, her heart pounding but her mind clear. She had said everything she needed to say. Hargrove's closing argument was polished and professional, emphasizing economic benefits and property rights. But June noticed that several jurors seemed unmoved, their eyes occasionally drifting back to her. When both sides had finished, Judge Rivera addressed the jury. You have heard the evidence and arguments in this case. You must now determine whether Belworth Development has met the legal requirements to invoke eminent domain under the Urban Development Act. I will provide you with detailed instructions on the applicable law. Please remember that your decision must be based solely on the evidence presented and the law as I have explained it to you. As the jury filed out to begin deliberations, June remained seated, suddenly exhausted. The adrenaline that had carried her through the past days was fading, leaving her drained but oddly peaceful. She had done everything she could. Hargrove approached her table, his expression unreadable. Regardless of the outcome, Ms. Wong, you've presented a remarkable case. If you ever decide to leave the grocery business, you might consider law school. June looked up at him, surprised by what seemed like genuine respect in his voice. Thank you, Mr. Hargrove, but I'm happy with my life as it is, assuming I still have a home at the end of this. He nodded and turned away, joining his colleagues who were huddled in urgent discussion. June gathered her papers slowly, preparing for what might be a long wait, but the jury returned after only 2 hours, much sooner than anyone had expected. A hush fell over the courtroom as they filed in, their faces solemn. June's hands gripped the edge of her table, her knuckles white with tension. The foreman handed a slip of paper to the bailiff, who delivered it to Judge Rivera. The judge read it silently, her expression giving nothing away. Has the jury reached a verdict? She asked formally. We have, Your Honor, the foreman replied, standing. June closed her eyes briefly, then opened them to face whatever came next. The courtroom fell completely silent as Judge Rivera spoke. Will the defendant please rise? June stood on trembling legs, her heart pounding so loudly she was sure everyone could hear it. Across the aisle, Richard Hargrove and his team rose as well, their faces tense with anticipation. Mr. Foreman, has the jury reached a unanimous verdict? Judge Rivera asked. We have, Your Honor, the foreman replied, a middle-aged man with kind eyes that briefly met June's. On the matter of Belworth Development versus Wong, how do you find? The foreman cleared his throat. We find in favor of the defendant, June Wong. For a moment, June couldn't breathe. The words seemed to hang in the air, unreal. Then a wave of sound swept over her as the spectators erupted in cheers and applause. Mrs. Patel was crying openly, and several of June's former neighbors were hugging each other. Order, called Judge Rivera, tapping her gavel. Order in the court. As the room quieted, she continued. The jury has determined that Belworth Development has failed to meet the statutory requirements for invoking eminent domain under Section 4.7 of the Urban Development Act. Their petition to compel the sale of 427 Oak Street is therefore denied. June sank back into her chair, tears welling in her eyes. Her home was safe. All those hours of study, all those nights spent poring over legal texts instead of sleeping, it had all been worth it. Judge Rivera wasn't finished. Furthermore, based on the evidence presented regarding Bellworth's business practices, I am referring this matter to the State Attorney General's office for investigation into potential violations of fair housing and consumer protection laws. At the Bellworth table, faces darkened. William Foster leaned over to whisper urgently to one of the company executives, who shook his head firmly. Court is adjourned, Judge Rivera announced, bringing down her gavel one final time. People immediately surrounded June, offering congratulations and thanks. A local reporter pushed through with a photographer in tow. "Ms. Wong, how does it feel to defeat one of the biggest development companies in the state?" she asked, thrusting a microphone toward June. "I'm just glad it's over," June replied honestly, "and I hope this helps others who might be facing similar situations." As the crowd slowly dispersed, June gathered her documents, still dazed by the outcome. She was nearly at the door when she heard someone call her name. Turning, she saw Richard Hargrove approaching, his expression unreadable. "Ms. Wong," he said, extending his hand. "Congratulations." June hesitated, then shook it. "Thank you, Mr. Hargrove. You know," he said quietly, "in 20 years of practice I've never seen anything quite like what you did in this courtroom." "I just fought for my home," June replied simply. Hargrove nodded. "Well, you fought brilliantly. I've been instructed to inform you that Bellworth will not be appealing the decision." June's eyes widened in surprise. That was unexpected. The publicity would be problematic, Hargrove admitted, especially with the AG's investigation pending. The company would prefer to cut its losses. "I see." Hargrove hesitated, then added, "For what it's worth, I'm glad you won. Sometimes the system works the way it should." With that, he nodded respectfully and walked away, leaving June to stare after him in wonder. Outside the courthouse, the bright afternoon sunlight seemed to match June's mood. Mrs. Patel was waiting for her at the bottom of the steps. "You did it, dear," the older woman said, embracing her. "You stood up to them and won." "I wish I could have done the same for you and the others," June said, suddenly aware that her victory was bittersweet. So many had already lost their homes. "Don't think about that now," Mrs. Patel said firmly. "Today is for celebrating." That evening, June's small house was filled with neighbors and friends. Someone had brought food and other drinks, and her living room buzzed with conversation and laughter. In one corner, her friend May was deep in discussion with the local reporter, gesturing animatedly. "You're a local hero now," May said when June approached. "Lisa here wants to do a feature story on you for the weekend edition." The reporter nodded eagerly. "People are already calling your case Wong versus Goliath. Would you be willing to talk about your legal background and how you prepared?" "I suppose so," June agreed, still uncomfortable with the attention. "But I'd rather focus on the issue itself, how big companies use tactics like this to push people out of their neighborhoods." "Even better," Lisa said, jotting notes. A call to action. As the evening wore on, June found herself sitting on her back porch steps, taking a moment of quiet amid the celebration. The old elm tree her grandfather had planted cast long shadows in the twilight, its leaves rustling gently in the breeze. "There you are," came a voice. June looked up to see Carlos Rodriguez, a community organizer she knew casually from local meetings. He sat down beside her, offering a glass of lemonade. "Quite a day," he said, his expression thoughtful. "Yes," June agreed. "Still doesn't seem real." "I've been fighting developers like Bellworth for years," Carlos said. "Usually we lose. What you did in there, it's given a lot of people hope." June sipped her lemonade. "I just used what I knew. I was lucky." "It wasn't luck," Carlos insisted. "It was preparation, courage, and knowing your rights." He paused. "Have you thought about what comes next?" "Honestly, I've been too focused on not losing my home to think beyond that." Carlos nodded. "The community center is looking for someone to run legal education workshops, teaching people their rights, how to navigate the system. After what I saw in that courtroom, I can't think of anyone better qualified." June looked at him in surprise. "But I'm not a lawyer. Sometimes that's an advantage. You speak in plain language people can understand, not legal jargon that intimidates them. He handed her a card. Think about it. The pay isn't great, but it's more than friendly market, and you'd be doing important work. As Carlos returned to the party, June remained on the steps, turning the card over in her hands. The idea of helping others navigate the legal system, of using what she'd learned to empower her community, it felt right in a way she couldn't quite explain. The next morning, June woke early. The house was quiet again, the celebration over. She made tea and carried it to the kitchen table, where she used to spread out her legal books during those long nights of preparation. Now those same books were stacked neatly on the corner, their purpose fulfilled. Or was it? June sipped her tea, thinking about Carlos's offer, about all the others in situations like hers who didn't have 15 years of legal secretary experience to fall back on. People who might lose their homes simply because they didn't know how to fight back. Her decision made, June picked up the phone and dialed the number on Carlos's card. 6 months later, the community center classroom was full, every seat taken. At the front, June stood beside a whiteboard covered with notes on tenant rights and property law. Her students, a diverse group of all ages, listened attentively as she explained the intricacies of housing regulations in simple, clear language. Remember, June told them, the law can seem intimidating, but it belongs to all of us, not just those who can afford expensive attorneys. After class, a young woman approached her desk, clutching an eviction notice. Do you really think I can fight this? She asked, her voice uncertain. June smiled reassuringly. I know you can. Let's look at it together. As they bent over the document, June felt a deep sense of satisfaction. Winning her case had saved her home, but this, helping others stand up for themselves, had given her life new purpose. Outside the window of the community center, construction equipment sat idle on the vacant lots where Bellworth had planned their development. The state investigation had uncovered multiple violations, resulting in heavy fines and a suspension of their building permits. Rumors circulated that the company might sell the land to a nonprofit dedicated to affordable housing. June's case had become a rallying point for the community, inspiring others to challenge unfair development practices. A coalition of neighborhood groups had successfully lobbied for amendments to the Urban Development Act, strengthening protections for homeowners and requiring meaningful community benefits for any project invoking eminent domain. At home that evening, June added a new newspaper clipping to her grandfather's album, a feature about the community legal education program she now ran. She smiled as she traced her finger over the headline, Local Hero Turns Courtroom Victory into Community Movement. In the kitchen doorframe, where generations of height marks recorded her family's history, June had recently added a new measurement, the first of many neighborhood children who now came to her home regularly for tutoring and encouragement. The house that her grandfather built, that she had fought so hard to save, had become more than just her home. It was a symbol of hope, a reminder that sometimes, against all odds, David really could defeat Goliath, and June Wong, once mocked in court for being just a simple grocery clerk, had found her true calling, ensuring that the next person who stood up against a powerful opponent wouldn't have to do it alone.